The next case is Curtis Hart and Catherine Hart. I think they're both here. I see Ms. Hart.
Here.
And Curtis Hart, are you here?
I am.
All right. All right. This is a motion brought by, I believe, Ms. Hart to see the children, or I forget how many right now. So Ms. Hart, do you want to start, and then I'll go to Curtis Hart and let him respond, okay?
Okay, thank you, Your Honor.
And would you speak up just a little bit?
Okay.
There you go.
Okay. So I prepared what I was going to say here. So I take full responsibility for the mistakes that I made. I was at that time unable to process the grief and the loss for my marriage ending and the trauma that I had suffered from the extreme verbal abuse. The abuse and harassment continued after we separated, as the police records show, to the point that I had a complete mental breakdown. And during that time, my drinking had become unmanageable, and I eventually ended up homeless. I do want to address some of the accusations presented in Curtis and Mandy's declarations, which are blanketed with false accusations. I never abused or neglected my son. He had good school attendance and never missed his doctor or dental appointments. There are no police records, nor had I been involved in any criminal activity or illegal drug use. I've made multiple attempts to contact Eric, but was denied every time, as even declared in their declarations. I've been completely alienated from maintaining a loving, stable, consistent, and nurturing relationship with my son, even knowing, as they declared, that Eric had separation issues and was affecting him mentally. On December 23rd of 2019, I filed and served documentation showing I was in compliance with the parenting plan provisions as instructed by Mandy Hart, and she said that they'd let me see Eric for Christmas Eve. Yet again, I was alienated and not even allowed phone calls, as I was told that was not enough. Your Honor, I respectfully ask the court to deny Curtis's proposed parenting plan. I'm currently on state assistance, as you can see from the fee waiver, and I don't have the means to do supervised visits in the facility. And I don't want to mess up any progress Eric has made over the last 2 years. That is why in my proposed temporary order that we begin with every other weekend. I believe that Curtis's proposed plan is nothing more than vindictive rather than him trying to cooperate with me and do what's best for our son. Curtis is not Eric's full-time physical caretaker. Eric has not been in Curtis's full-time physical care supervision since 2019, as stated on page 3 of Curtis's life's declaration. I've been in stable housing for over a year. I just renewed my 1-year lease last month. I have a 3-year-old daughter, and there's a declaration from her teacher who has been coming into our home once a week for her schooling since we moved in. I've also been in mental health counseling for over a year, twice a week, and I realized that I needed to address my mental health in order to maintain a lifetime of sobriety. Your Honor, I only have my son's best interest at heart. He needs me as mother in his life, and my goal is to have my son live with me rather than his grandparents full time. I'm in treatment, and I have complied with the previous parenting plan provisions, and I've provided all the documentation showing so per court orders in April 2017. As you can see, no other court orders for modification have been signed by a judge other than the original parenting plan in 2017, and I've complied with section 4 of that plan, and I respectfully ask that you grant my temporary order.
Mr. Hart?
Yes, Your Honor.
Any response?
Yes. Well, Your Honor, my ex-wife, I was really hoping that she was going to take full responsibility for not being in her son's life for 6 of his 9 years, but it sounds like she's still trying to blame me for leaving the marriage, that she had an affair and moved her boyfriend into the house I moved out. She very quickly just kept on drinking to the point where I had to take her to court to get the papers are there. It's a I'm sorry, I'm a bit flustered right at the moment. I had to take her to court to make her stop drinking in front of Eric, and she had him removed by the courts for several weeks. When she got him back, she destroyed every single thing inside of her house, all the glass. She did that in a blackout rage the day she got Eric back from not having him for several weeks because of the drinking issues. After that, there was a contempt of order charge that was levied by the courts because of that drinking incident. And that's why she can't see her son. She's never lost custody. I have to also follow the court order that allows her not to see him. And the ball has been in her court this entire time. She's never filed anything as far as I know. I've never been served anything by anybody. There's a lot of what she just said is just false. And what I'm asking for is I believe in Eric's best interest. She doesn't know Eric. She hasn't seen him since he was about 3 years old, or 4, I guess. Anyways, she hasn't seen him in about 6 years. There's a Christopher Antler on the screen now. I'm going to just keep on talking. And so anyways, she hasn't seen him for about 6 years. She doesn't know him. He doesn't know her. Unsupervised visits is just not in his best interest at all. I believe that there's something called reunification that needs to happen. That she doesn't know him. She has made no strides to be in his life whatsoever. She sent no Christmas cards, no birthday cards, none of that. And my parenting plan is just asking for basically the same thing she is, only supervised visits, so that he can get used to the person that he doesn't know. And I'd also like to not have every single birthday forever, not with my son. I think that that's a bit much to ask for. And I was also just like to point out that the original parenting plan did give her more than what she's asking for now. And all she had to do was go to court and get rid of the contempt charge. But instead, she wanted to do all this. So my son lives right next door to me. I see him every single day. She doesn't know how much I'm involved with his life because she hasn't been involved with his life one tiny bit in 6 years. And so I'm just going to be repeating myself basically if I keep on going at this point. So,
all right. Thank you.
There you are. Okay.
Ms. Hart, you get a chance to respond.
Like I said, I do take accountability for the things that I did back in 2017. I did make several attempts to contact him, get him Christmas presents, birthday presents, and was denied. Or when they were accepted by his grandmother, they said that they were from somebody else other than me. Curtis was served court documents back in December, December 23rd of 2019, with all my treatment records, clean UAs, everything. And I was 5 months pregnant at the time. I was sober. I had been sober, and it is on court record that those papers were filed, and he was served. It was after that I became homeless. But over this past year, like I had said, I've been in mental health counseling treatment. I've been sober for quite some time now. My 3-year-old daughter, well, she turns 3 tomorrow, she's never seen me intoxicated. So I have changed my life, and I've done all the things that the court required, above and beyond even. So I know that my son is ready to see me, to come home to see me. I heard him on the phone with my mom yesterday saying so, that he wanted to come home and see his mama.
All right. Thank you both. So there was a final parenting plan that was entered on November 22nd, 2017. Issues arose, and in 2018, the court suspended visitation with Ms. Hart, and that order has never been rescinded up until today. Ms. Hart has made some strides in dealing with her issues, and I want to compliment and acknowledge that. She's indicated that she's done an SUD assessment, that she's to do outpatient care. I think she's doing that. She indicates she's been sober for several months. And so now she's come back to court, understandably, to remove the 2018 suspension in order to see her son. I think we need to take a couple steps before we get to that point. And so, Ms. Hart, I'm going to tell you up front that I've been through this process a number of times where a child has not seen a parent for a while, and we have to reintroduce or introduce the child to the parent and do it in a way that's safe. And it's going to take so long, you're probably going to be very frustrated. But I want you to look at the end of the road where you will have a fairly normal relationship with your son. But we need to take some steps to get there. The first step I'm going to do is appoint a guardian ad litem to do an investigation of Ms. Hart and also just look at the whole living situation for Eric. So I need to do that first. I'm not going to order any kind of contact between Eric and Ms. Hart for at least a month while the guardian ad litem does an investigation. And that's because I'm not sure what that contact looks like. I don't know if telephone calls are appropriate. I don't know if reunification counseling is appropriate. I need assistance from the guardian ad litem in order to determine that. All right. The order that Ms. Hart provided was an order on adequate cause. And I wanted to address that. I'm not sure that at this point, that's the order we want. Let me just person. There we go.
I'm sorry, Your Honor, I can't hear.
Yeah, I just muted somebody.
Thank you.
We may do an order for adequate cause, which would cause you to go to a trial to change the parenting plan from what it was in 2017. But right now, what I see is I'm addressing whether the contempt order of 2018 should remain in effect. And if not, how does that change? I think that's something I do from this docket. And so I'm going to retain everybody for a while, at least until we get a guardian ad litem report and maybe take some steps to reunite Ms. Hart with Eric. Okay. So the way we appoint a guardian ad litem is we give 3 names. If you know of any of these people, let me know, and we'll see whether they're appropriate to go forward or not. So the individuals are
Heather Paul, David Turnbull, and Ann Hyde.
I didn't hear any of those.
okay. So I'm going to tell you Heather Call. I think it's Kahl. Amy Turnbull and Ann Height. Either of you know any of those? Okay. So I'm going to appoint Heather Call as the guardian ad litem here. All right. I'm going to put this over a month, and that's going to be to April 12th. To give Ms. Call at least some time to meet with you and get started. I don't know that she'll be completed in her investigation, but to get started. In the meantime, nothing's going to change. That contempt order will remain in effect. Ms. Hart, you're not to have contact with Eric until we do this investigation. Okay.
Okay.
Mr. Hart, any questions?
So do I contact Ms. Call, or does Catherine?
She should contact you. In the order that I put together appointing her, I provide your contact information.
Okay.
So she will contact you. Good
All right.
question. Ms. Hart, any questions?
No,
Okay. All right. We'll see you back here on the 12th and we'll go from there.
okay, thank you, Your Honor.
Thank you.
All right, Curtis Hart and Catherine Hart. I see Ms. Hart. I thought I saw Mr. Hart here also. Good morning, Ms. Call.
Morning, Your Honor.
What came up was both parties made a motion to have the county pay the guardian ad litem fee, and they filed financial declarations that, so far as I can tell, does qualify them to have the county pay. So I prepared an order amending the appointment. Let me just write amended on here. That does provide for county pay of the guardian ad litem. Okay.
All right.
Ms. Call, have you had a chance to meet with the parties at all or contact them?
Not yet. We've had contact. They've both returned their questionnaires, their intake forms. I was waiting to move forward more until we had a ruling on this particular issue. So now that I know the answer to that, I'll go ahead and move forward and we'll get things underway. They've both been communicative. They've both returned their paperwork. So I have good reason to think this is going to go well.
Okay. If I set a review on the May 10th, would that be appropriate?
Yes.
Okay. So Ms. Hart, will May 10th work for you to come back?
Still, Your Honor.
Okay. So I'll set another review on May 10th at 9 o'clock, and that will be to get an update on the guardian ad litem report. I think there was a request for adequate cause in this case, and I held off on that decision until I got some information from the guardian ad litem. So hopefully by then, or perhaps within another month of that date, I'll be in a position to make a decision. Okay.
I think I can help you out with that. We do, Your Honor, there's a hearing scheduled next Wednesday morning at 9 a.m. and to deal with the filing of the fee issue. And so would that hearing still be necessary on the 19th?
Let me take a look here.
One of the reasons I ask is because I'm actually scheduled to be at a hearing in Clark County as well at the same time. So I'm curious about that.
Tell me again, what does that hearing involve?
This had to do with the fee waiver.
Oh, for the guardian ad litem?
Correct. Yeah, the guardian ad litem.
That can be struck then, if that's all that's on for next week.
Ms. Hart, am I correct in saying that?
That's right.
Okay.
Oh, I see. There, it does show a notice of hearing for the 19th. Well, I've already determined that I will have the county pay the fees. So I've granted your motion, so we don't need to be here on the 19th. Okay. So we'll strike that hearing. We'll be back here on May 10th.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. I'm going to call a couple matters that I believe are going to be shorter. So let's first call Curtis Hart and Catherine Hart. I think they're both here. And Ms. Call is the guardian ad litem. I think I've set this on for today just to make sure there was contact with Ms. Call and that we're moving forward on the guardian ad litem report. Ms. Call, do you want to respond?
Yes, I've been able to do home visits with both parties. I've been up to kiddo's school and met with his teacher. I'd like to bring attention to the court that I found out in my home visit at Dad's house, at Mr. Hart's house, that kiddo is actually not living with Dad. He lives across the street at his grandparents' house. Yesterday, I received third-party information that there's a pretty serious health diagnosis that's been given to Grandma. And so I need to do a little more investigation to make sure that that's accurate and true. I'd also like to, based on the investigation at this point, I'd like to request, I asked Mr. Hart if he'd be willing to submit to a hair follicle test based on some allegations that have been made. He said he would not. So I'd like to ask the court to order that, as well as a mental health assessment. I'm concerned that this diagnosis of Grandma's is going to deeply impact Eric's living situation. So I want to make sure that going forward, if we have to make some living adjustments, that there's a healthy, safe place for him to be. Other than that, Mr. Hart has not provided me any collateral references to speak with. I've kind of just been finding these things on my own. At this point, I'm receiving lots of communication from Miss Catherine Hart and have had interaction with all of her collaterals and have received her tests.
Okay.
Am I frozen? There we go.
No, you're not. I have that your final report is scheduled for June 14th. Is that still a realistic date?
If I could request 2 more weeks to get some test results back, and to have time to do a little more investigation regarding the living situation for kiddo, that would be really helpful.
Okay. Mr. Hart, do you want to respond to the request by the JEL that you have a hair follicle test and a mental health evaluation?
I don't mind. I don't mind having a mental health evaluation. I see no reason to have a hair follicle test. Just because she asked me if I wanted to submit. I don't feel like it's necessary. I don't use drugs. I don't have a history of drug use. I don't have a history of drug and alcohol abuse. So there's just no reason for me to do it. If you're going to order it, I suppose I will, but I just don't feel like I need to prove my parenting to the state. I've been involved with Eric, his entire life, not just a third. So, I mean, if you're going to order it, I will. I don't see it necessary. I don't see it being, I don't have money for it. The state doesn't need to spend the money on it. I'm not a drug addict. I've been in my son's life the entire time. So if it's something that you're going to order, then I will, but I don't see it being necessary.
All right. Let me hear from Ms. Hart. Any comment regarding this case?
Just that I've submitted months worth of clean negative UAs. I have absolutely no problem submitting to a hair follicle test. I've definitely been clean and sober for longer than 6 months. And Curtis has used drugs since he was 12. And so I believe that his heavy use of marijuana does contribute to a lot of his anger issues. And I think it would be an excellent idea.
Okay. Sometimes
Ms. Hart hasn't had any contact with me in 6 years, so I'm not really sure what she's talking about.
Your Honor, can I address this?
Sure, go ahead and then I'll make some decisions.
The request that I'm making is not a direct result of Ms. Hart's accusations. I've had multiple interactions with collateral parties who are concerned that drugs have been a factor and that there's very serious issues with anger management and harassment on Mr. Hart's part. This is not coming from one source.
Can I ask who these sources are? Because this is court. This is a public court. I got to know who my accusers are. If she's saying that people are saying that I have anger issues and drug abuse issues, that's something I would very much like to know. Who's saying that?
I think those individuals will be identified when the report comes out.
Okay.
We got you on for now, so I'm gonna keep working on it over here. You okay with that?
Let me mute this person here. Okay. All right, sometimes I will order a hair follicle test because we just want to have a level playing field and make sure where we're starting from. And if we're starting from a place of everybody's negative, that's great. But we need to have the test in order to determine that. So I think it makes sense to do that. So I am going to order a hair follicle test. I am going to order a mental health evaluation. You can do that either at Columbia Wellness, I believe, or Core Health, and you can talk to them about having that completed. I will extend the time for Ms. Call to provide her final report to June 28th. I'm going to strike the hearing on June 14th. And if there's any issues that come up, you can always note a hearing in front of the court. But in the absence of that, our next time together then will be on June 28th, and we'll review the report by Ms. Call.
Thank you.
So
Your
am I
Honor.
going to get like a court order for that hair follicle test? And do I have to pay for that, or what's going on with that exactly?
That will be at your cost. I will do a bench order for it. It'll be available by tomorrow afternoon if you want to see the order.
So is that something I can fill out a fee waiver for, since it's being ordered on me?
I think you'd have to talk to the entity that does it. I think, well, I'm not sure where you're going to go to have that done. You'll have to talk to them to see if there's a way to waive that fee. I don't think I can do county pay on that.
Even
Your
though
Honor,
you're ordering it, you can't do county pay, even though it's a court order from the county?
Yes. Ms. Call.
Yes, Your Honor. I think it should also be noted that Mr. Hart told me in our interview that he and his wife, Amanda Hart, own a local spa in Kelso, and that is where he works and receives his income from. So while we were, and
I don't receive income from there. That's not true. I never said that.
Let's let Ms. Call finish, okay? And then I'll let you respond.
When I asked Mr. Hart how he supports himself and his son, his response was the income from the spa that he and his wife own together, and that he works for her and works there. I only give that information because this is now a county pay case, and he is asking for more county pay support.
Yes. That's because I qualify for that. I filled out the paperwork and I qualify. Therefore, there you go. Since you're bringing it up.
You'll need to talk to the entity that's going to do the test to see if there's a way to get the fees waived on it.
All right.
All right. Thank you. We'll see you back here on June 28th.
Thank you, Your Honor.
Thank you.